video off, right? And mute. So E1 will be with us, but you wouldn't be able to see it on Facebook.
No problem, sure.
Correct.
Haran, if you're also looking at the Facebook stream, you just mute the Facebook stream, right?
Okay, no, I don't have it on.
Okay.
Let me just fix this. Okay, I don't have color state. Oh well, never mind. Should be fine.
Just wait for a few more people to come in.
Okay. Actually, are they seeing us by chance? Because I want to fix my
We
color.
are live on Facebook even now.
Oh, we are. Okay, fine. Oh, let's not bother. Okay.
There's only two people here, which is probably E1 and myself.
Oh, okay. Well, you know what? Let me just turn off video for 1 second.
Okay.
What do you think? Yeah, I can leave it.
Yeah, you're fine, I believe.
Yeah. Hmm.
Good morning, Daniil. We just give it a few more minutes.
Yes.
And then we'll get into it.
All right, so let me.
All right, I'll give it 2 more minutes and 11:05.
Okay, certainly. Yes, that's fine.
So as they say, we're waiting for life to build.
Okay. Okay. Oh yes, good morning, Daniil.
Right, so we're actually a few seconds delayed on Facebook from Zoom. The questions might come in a bit delayed as well.
Okay. All right, that's fine.
All right, so let's get into it. Okay, good
Yeah,
morning.
certainly.
Good morning to all our viewers. Welcome to our first interactive Facebook Live series session. I am Shelly Dalabai, the Manager of Corporate Communications at the Equal Opportunity Commission, and I am joined by my colleague and co-host, Mr. Haran Ramkaransing, who
Hi,
is
good morning, everyone, and good morning, Shelley.
Good morning, Haran. He's the Director of Legal Services at the Equal Opportunity Commission. So he is here to answer any questions you may have about the Equal Opportunity Act and also to respond to some of your complaints and concerns as well live here on Facebook, right? So it's really meant to be an interactive session. So yes, we would be raising awareness and giving you information, but we really also would like you to send in your questions, your concerns, and so on, and we will field it for you right here in real time. Right. So while we
Yes.
wait for some more people to join us, let's just really quickly get into the Equal Opportunity Act, which really prohibits and prevents certain kinds of discrimination, right, and also seeks to promote equal opportunity between persons of different statuses. Now, what I mean when I say a status, it's really like an inherent characteristic, something you don't really have control or much control over, right? So the Equal Opportunity Act, the status grounds that it covers are sex, religion, disability, marital status, origin, including geographic origin, race, and ethnicity, right? And the categories covered are provision of goods and services, provision of accommodation, employment, and education. So let's say, for instance, you are an engineer and you see a job posted and it says only engineers from Port of Spain needed, right? And you're from San Fernando, that is discrimination based on geographic origin, right? So the category must be tied to a status ground, right? Another example, for instance, you are a man and you go into a clothing store and you want to purchase a dress and the store clerk absolutely refuses to sell this dress to you, that is discrimination based on sex. She's not selling you the dress just because you are a man, right? So those are the status grounds and the categories currently covered by the Equal Opportunity Act. Now, I want to pass it to Haran for a bit because the Equal Opportunity Commission, we implement the Equal Opportunity Act, and part of our responsibility is also recommending amendments for the Act. So I would let Haran get into that a bit.
Yes. Now, the Equal Opportunity Commission was created, and I believe Shelley made this point, by the Equal Opportunity Act. So we are what you call a statutory organization, and we take our mandate from the Equal Opportunity Act. You know, just to digress a little, sometimes we get a lot of complaints and a lot of matters from a lot of persons, and we have to say, you know, while you might have a valid complaint in that it is something that is bothering you, it does not fall within our statutory jurisdiction. Because we can only do what the Equal Opportunity Act, you know, provides and what it allows us to do. And just to stick a pin, you listed a number of status grounds on which complaints can be lodged. For example, you mentioned race, ethnicity, sex, disability, marital status, geographical origin. But there might be other grounds on which a person could be discriminated against. Unfortunately, we are only empowered to deal with those grounds that are listed in the Act. So one of our mandates is to make recommendations for amendments to the Equal Opportunity Act. So for example, we have recommended to the Attorney General that certain other grounds be added to the Equal Opportunity Act. And I always like to throw out the question, think about the grounds on which a person could be discriminated. The Equal Opportunity Act really seeks to protect against discrimination based on personal and inherent characteristics over which one may not have a control over. For example, you can't control your race or your religion. You can't control, your sex, your origin, who your parents are. There might be other grounds. Well, I said you can't control your religion. You may be able to change your religion, yes, but at the same time, one's religious identity is so fundamental to one's being that one should not be forced to change one's religion for a job or for promotion or that sort of thing, or to get into a school. So these are things that one cannot change, like one's sex or one's race, or one cannot change easily, or one should not be asked to change, like one's religion. Another area one cannot change is one's age. Now, age is not covered by the Equal Opportunity Act. So we have recommended to the Attorney General that age be added as a status ground. And then in Trinidad and Tobago, there's what you call the elephant in the room, which is sexual orientation. The Equal Opportunity Act covers sex, but sex really refers to differential treatment between men and women. And you gave the example. If a man goes into a store and does not receive the goods and services, but a woman would receive the goods and services in the form of buying a dress, then that is sex-based discrimination. For example, if a woman is being paid less for doing the same job, that is sex-based discrimination. But it also works the other way around, in that there are cases from other countries where if a woman can retire at 60, but a man has to work until 65 to get the same retirement benefits, the same pension, the same everything, that is also sex-based discrimination. So that it's important to think that sex-based discrimination is not only discrimination against women, it's discrimination on the basis of your sex. So a man can claim sex-based discrimination too. But the short point I'm trying to make is that sex-based discrimination is about discrimination based on whether you're a man or a woman. It does not include things like your sexual orientation. That is a separate and distinct area. It is not covered by the Equal Opportunity Act. So we have recommended to the Attorney General that the Act be amended to include sexual orientation. So those are the two, what we will call big ticket amendments that we have recommended. We've also recommended with respect to disability that certain medical conditions be deemed disabilities. For example, you have heart disease, you have diabetes, you have HIV/AIDS. Now, all of these would be covered under the Equal Opportunity Act, but you would have to fit it under the existing definition. Whereas when we looked at other countries, their legislation says as long as you have certain conditions, that is deemed to be a disability, that will entitle you to protection under their legislation. So those are really the three big ticket amendments that I said. The first two really are expanding the scope, that is to include age and sexual orientation. But the third is really, which is about disabilities, really to bring clarity to this area. Because, there was some dispute for a number of years whether persons infected or affected by HIV were covered by the Equal Opportunity Act. And they are covered under the rubric of disability. So the amendment is really to clarify that for the benefit of that community, and also for the benefit of other persons who are affected by other conditions such as multiple sclerosis, cancer, diabetes, heart disease, that sort of thing.
Yeah. Thank you, Harold. I think it's really important. I mean, the point that you bring up is really important to note that the Equal Opportunity Act is not just a stagnant piece of legislation. That's something that the Equal Opportunity Commission is always looking at, always reviewing, depending on the context, depending on the environment, and we're able to make certain recommendations to have the act be amended. And those are some really good points that you brought up. Karen, thank you for that. So let's go into the services that we offer at the Equal Opportunity Commission. And of course, as I mentioned earlier, you can submit your questions, you can comment your questions, and we will answer it for you as well. Right? So some of the services that we offer are appearances on webinars or panels. So as the leading state advocate on discrimination, we appear on various platforms to speak to discrimination, right? So if an employer wants to have a webinar, we would very much like to come in, and it's free of charge for our parents to come in and present. We also do virtual education sessions with organizations. So if, for instance, your HR department wants to implement certain policies, we come in and we present on sexual harassment, accommodating people with disabilities, persons with disabilities, and so on, right? Also organizations that generally are looking to proactively promote inclusivity in the workplace. We also do partnerships, right? So we partner with various NGOs, community-based organizations, NPOs, CSOs, etc. We support their programs, and we also magnify their calls for justice, right? So for instance, in August, we partnered with the Trinidad and Tobago Football Association to host a roundtable discussion on racism in sports, right? And the last service that we offer, and it's the service that we would go into some detail about, it's our main service, which is we deal with complaints, right? So we are empowered by the Equal Opportunity Act to receive, investigate, and conciliate complaints, right? So Haran will be, good morning, Suzanne, good morning, Renato. Sorry, I am only now seeing your comments. Yes. So Haran would go into some details about the process to lodge a complaint and what it means for you and how it can benefit you and the communities that you represent or are a part of when you lodge a complaint.
Yes, thank you, Shelley. Well, as we indicated, the Equal Opportunity Act prohibits discrimination in, just to repeat, in 4 broad areas, that is employment, education, the provision of goods and services, and the provision of accommodation, where that discrimination is tied to a personal and inherent characteristic known as a status ground. And we had said that the status grounds protected are race, ethnicity, sex, religion, marital status, geographic origin, including geographical origin and disability. So it's not just enough to say, well, you know, we pass legislation saying, well, these things are outlawed. The next question would then be, well, if I'm the victim of some of this sort of conduct, what is my redress? So the Equal Opportunity Act really created a mechanism. Well, one of the purposes of the commission, perhaps you could say the bread and butter purpose of the commission, is to really receive and investigate, to treat with complaints of this nature. So that is to say, members of the public and any member of the public, any member of the public who believes that they've been subjected to this sort of complaint, this sort of conduct, can lodge a complaint with the commission. And we are mandated to receive the complaint, investigate it, and where possible, conciliate the complaint. Just to mention, every matter is not resolved at conciliation. The Act creates a second institution, which is the Equal Opportunity Tribunal, and they are a court. They are chaired by a judge, and the Act provides that if the complaint is unresolved by the commission, then it can be sent there for hearing and adjudication. So just to mention, there are 2 institutions created by the Equal Opportunity Act: the Commission, which we are employees of or part of, and the Tribunal, which is separate to us. That is the institute that I always like to draw the parallel with the Ministry of Labor and the Industrial Courts. You know, the Ministry of Labor's job is to conciliate complaints, trade disputes. Just to stick a pin, they only conciliate, whereas we investigate and conciliate. So that when you report a trade dispute to the Ministry of Labor, or rather when a trade union reports a trade dispute to the Ministry of Labor, their job is to simply bring the parties to the table for discussion. And if it cannot be resolved, they certify it as unresolved and refer it to the Industrial Court. 2 things to note. Any member of the public can bring a complaint to us. You don't have to be a trade union or anything of that sort. As a matter of fact, the person who's complaining has to be the person who's affected by the complaint. So while, for example, a trade union or an attorney or an industrial relations consultant or somebody can lodge the complaint on behalf of the person, or some sort of advocate or some sort of civil society advocate or group can lodge it on behalf of the person, they're simply doing it on behalf of the person. It must be that person's complaint. So when the person brings the complaint to us, we would call the person in for a meeting. Well, I use the expression call them in for a meeting because that's what we would do prior to COVID-19. But with all the restrictions and lockdown that is going on now, we would have to arrange the meeting virtually via Zoom or via Teams or what have you, you know, via email, that sort of thing. We have to use online platforms and electronic platforms. But you know, so we would schedule a meeting with the person. We would ask the person to provide more information, more documents. sometimes we would have to focus, trying to get a person to focus onto the nature of the complaint. In other words, if you're saying you're discriminated against, because of your, let's just say your race, we would tend to ask you questions. Well, why do you think that? And one of the helpful things we would always ask is, can you point to persons of a different race who were treated better? This is what is known as comparators. That is because if for example, your employer is mean to everyone, let's just say they're saying, we are not going to allow anybody to take vacation leave in the month of December, then that by itself, now it may be an industrial relations issue, but there might necessarily be a discrimination issue, because they're not discriminating against any employee. They're saying no employee is allowed to take vacation during the month of December. I'm just using this as an example. If on the other hand, they're telling you that you can't take you can't take a vacation, but then other people came after you and applied for vacation in December and they're getting through, then I'm just using this as an example to say that could perhaps point to some sort of discrimination. I'm not saying that it is, I'm just saying it could perhaps, because the short point is really what we're looking for is evidence of how other people were treated compared to you. So these are the sorts of questions we would ask you. You would need to bring in your emails, your documents, all of these sorts of things. If after interviewing you, if we find that there is a complaint to be investigated, we would then write to the respondent who most of the complaints tend to be in employment. So let's just use the example of an employer. We will write to your employer and say, well, so-and-so has lodged a complaint, and these are the details of the complaint. We would say what the complaint is, and then we would ask them a number of questions, and they would say, well, we require you to provide us with this document, this information, that sort of thing. Sometimes a question we've been asked before is, if I lodge a complaint, can you withhold that information from the employer? In other words, can you say a complaint has been lodged against you but not identify the person? And our response is that, no, if you want us to investigate, we have to let your employer know who is the person lodging the complaint. So that is something to think about. So we would ask your employer for information. We would give them a time frame, say 1 month or thereabouts. But, and if they ask for an extension, we would accommodate as much as we can. And the reality is, because of COVID-19, a lot of employers are saying, well, we need more time because, our operations have been modified. So a lot of public sector employers are saying, well, we've closed our offices. And as a matter of fact, the Equal Opportunity Commission itself has closed its offices and staff are working from home. So that obviously presents certain challenges in accessing files and documents if all of your files and records are not digitized. So because of that, we have to be understanding. People tend to say, well, no, I want you to demand that the employer do this in 1 month. And if they don't, and our response is, we are not your advocate. If we are your attorney, then, for example, you would say we would take instructions from you, in the same way that if you pay an attorney, that attorney is obligated to take your instructions and do what you require them to do. But we are a public body. We exercise in order to launch an investigation, someone has to lodge a complaint. But when we investigate a complaint, we investigate it in accordance with the public interest and in accordance with a public duty, so that it is not for you to direct us and say, no, I don't want you to grant the person an extension, or I want you to, if your regular practice is to give them 1 month, I want you to give them 1 week instead. Now, if you can give us a compelling reason, for example, and there might be matters, let's just say your child is in a case of discrimination on the ground of education. If your child is being put out of school, then our processes would dictate that, yes, we would have to perhaps use a different timeline and a different mechanism when investigating a complaint of a child who's been put out of school. Because obviously we understand that there is an urgency there to get that child back into school as much as possible. But, so it is something that we would do that in the public interest, because we recognize it as a public interest in ensuring that all children are in school. I'm using the example of a child in school, but again, we're in a COVID-19 situation. So perhaps it's not the best example, because now everyone is doing online learning. But let's just throw your mind back to 2 years when all children were in school. Because, and we would sometimes get complaints that my child is not being admitted or my child is being put out of the physical school premises, when 2 years ago, all children were in school. Well, last year, sorry, all children were in physical schools. But so yes, so we would try to investigate. When we get the response, we would review the information. We may discuss some of the information with you. Again, because I always like to stress, we are not your attorneys or your advocates. people tend to think that when we get a response from a respondent, we should simply hand that response over to them. And no, that is not our mandate. Our mandate is not to source documents from somebody, because we have the power to ask for a wide range of questions. And it is not our duty or mandate to source these documents and hand them over to you. We would try to discuss with you the information that the respondent has provided. Many times when we get the information and we discuss it with the complainant, it brings some clarity to the matter. And the complainant is better able to understand, well, this is what happened, or this is the situation. So they might say, well, okay, I am satisfied, or I better understand what took place. Sometimes, on the other hand, the complainant is able to say, well, they said so and so, but this is not true. This is what I know, and this is the information that I have. So in a situation like that, we would then write back to the employer again and say, well, you said so and so, but we have been informed such and such, and we would ask them further questions. So it's really a question and answer process, and this can go on and on and on for a little while. We try not to have this go on indefinitely, but sometimes the nature of the investigation is such that you would have to keep asking questions. An investigation is really a systematic inquiry into a matter. And we've had situations where the answers that the employer or the respondent gives raises more questions. They answer themselves. Sometimes we don't even need to discuss it with the complainant. We can just read the answer and say, well, this answer really is not a sound answer. There are more loopholes in these answers, so that we can go on through this process for quite some time sometimes.
Haran,
sorry. Mm-hmm.
Haran, sorry to cut. I'm seeing.
Oh, sure, of course, yes.
I'm seeing a question in the comment section.
Yes.
Before I get to the question, I just wanted to note two really important things.
Yes.
One, you mentioned that the person has to lodge a complaint.
Yes.
We can't go investigate a complaint unless it's lodged. So we would need the cooperation of the person. We would need that person and members of the public to take the first step and lodge a complaint, and then we can investigate from there. So I think that's really important to note.
Yes.
I think also it's important to know that we send out a notice. That the example you gave of an employee, we send out a notice, and the employer has to respond to this notice. So let's say an employee lodges a complaint, and the employer doesn't think that it makes any sense, or they don't have a valid complaint. The employer still has to respond to the notice that we send to them when we are trying to investigate the complaint. Haran, could you just tell us how we go about making sure that the respondent responds to our notice, and any, if at all, fines that they need to pay if they don't?
Yeah, certainly. So as I said, we are empowered to send notices to the respondent, and under the Equal Opportunity Act, the Act creates an offense. Now, I just to stick a pin. People ask, can you be fined for discrimination? No, discrimination is not a criminal matter, but the Act does create a criminal offense of what is called in legal jargon is known as obstruction offenses. So if the employer or the respondent, and I just want to also mention that we can send a notice to any party. It doesn't have to be, sorry, the employer. Sorry about that. It doesn't have to be the employer. We can send a notice to any party. And if the person fails or refuses to respond without a reasonable excuse, we can file a summons in the magistrate's court. In the local language, we say we bring them up before the court. We take out a summons, as ordinary people would say, we bring them up before the magistrate. So we will file a summons in the magistrate's court, and it can be served on them, and they will be summoned to court. And and they would have to say what is the excuse for non-compliance. And if the magistrate finds that their excuse is not a reasonable excuse, they can be fined under the Equal Opportunity Act a maximum fine of $1,000 per day in the case of an individual, or $5,000 per day in the case of a body corporate, for each and every day that they have failed and or refused to comply with the notice to provide information. But again, I always like to stress it's not what you call a default fine. It's not an automatic fine. The magistrate would have to adjudicate rather that that there was not a reasonable excuse for your failure or refusal to comply with the notice.
Okay, thanks, Harold. I have a question here from Ronako Osborne. He's asking if you have a complaint, what is the time frame for the virtual meeting and or any form of feedback?
Well, to begin with, if you have a complaint, you have to lodge it within 6 months of the alleged incident. While you're asking what the time frame for the meeting with our staff, I think the first time frame you need to know is that you have to come within 6 months of the date of the actual incident itself. Now there are things known as continuing breaches that happen over a period of time. And so we can look at that. And the Act provides that if you are not within the 6 months, you can be outside in exceptional circumstances. So exceptional circumstances means just that there has to be a compelling reason why you are outside of the 6 month period. Sometimes persons point to a correspondence between themselves. I'm going to use the employer, between themselves and the employer, where the employer made certain promises to them and say, because of that, well, they held off on taking action. So that might be an exceptional reason. But if your employer just simply promised, yes, I promise to look into your matter, and did not do anything else other than to look into your matter, and 6 months is elapsing and you haven't heard anything from them, then it's incumbent upon you to try and lodge your complaint within, try and get yourself within the 6 month window. So that's the first thing that you need to know, that you need to be within 6 months. When a complaint is lodged with us, we tend to, now there are a number of mechanisms by which you can lodge a complaint. You can lodge a complaint using our website. And the good thing about using our website is you could do this any time of the day or night. You could do it Sunday at 9 p.m. at night. You don't have to wait to come into our office during working hours. Well, in the past, as I said, when our office was open. When it was open, you could come in Monday to Friday from 8 a.m. to 4 p.m., and fill out a complaint form. You could even mail it into, you can use it, you can download a complaint form from our website, print it, and you can mail it in using TT Post. But let's just say you lodge a complaint as soon as it's received, and that's the date. Let's look at the date it's received, because if you mail it in, it might take a little while to get in. But let's just say you lodge it using our website. It will be responded within you will get an automatic response from the website, but then you will get a response from one of our clerical officers within 2 business days. That is the general standard. Because of COVID-19, sometimes they may take a little bit longer, but it's not something that will go on for weeks or anything of that sort. We set a standard of 2 business days. It could go on for 3 days sometimes, or 4 days, depending on if there are extenuating circumstances, but it's not going to be for more than a week. And then your matter would be assigned to someone who would then contact you. And again, they would try their best to contact you. Using email, they would be able to contact you within a few days. Now, sometimes their contact might just be to simply say, well, I am making contact with you and we need to schedule a meeting. And, again, because of COVID-19 and people working from home and people having different schedules, the meeting may not be scheduled right away, but at the very least, you would get, someone would be contacting you by email and acknowledging you within a week, and promising further contact or further discussion as we go along.
Yes, just to plug in here, Haran.
Yes.
The email that you can send your complaint to is complaints@eoc.gov.tt. So complaints with an S at the end. You can also send it to communications@eoc.gov.tt. The website is www.equalopportunity.gov.tt. And then you can also mail it in. We're at 55 to 57 Manic Street, Shogunas. And I will post this information to the Facebook page as well, where you can check it out. Haran, I have a question from Joseph O'Brien.
Yes.
He says, my girlfriend and I went to the doctor, and the nurse apparently spent 30 minutes telling her to break up with me because I am disabled. Can I do anything about this, or does she have to? The nurse even said that my girlfriend's diagnosis was caused by my disability.
All right. Well, while it is something distressing that you would have went through, what you would have to look at is, can you tie this or pin this to say one of the broad areas? Now, obviously you're pointing to the status of disability. What you're trying to look at really is the provision of goods and services, because it's obviously not an employment situation. It's not an education situation. You're saying when you went to a doctor and a nurse, so that you're trying to access medical services. So you're looking at the provision of goods and services. The challenge with your matter, now I know you've just put a short paragraph on Facebook, but what you would have to think about is, were you denied some sort of goods or services or facilities from the nurse? Or was your girlfriend denied? You know, it might be something that your girlfriend, so to begin with, more likely than not, it might be your girlfriend who would have to lodge a complaint, not you, because if it was that your girlfriend was trying to access the facilities or the services rather than you, I mean, is it, you know, put it very bluntly, who was visiting the doctor for what purpose? Is it your girlfriend and you were accompanying her, or is it that you were going for a medical visit? Because, you know, so that's the first question. That's the first thing you would need to look at. Who was accessing the services of the doctor? Was it you or your girlfriend? And then can you say, for example, that you were denied the services of the doctor or the nurse? But even if you weren't denied, if you were subjected to some sort of, you know, some sort of embarrassment or discomfort, because not just the denial of the services, but the manner in which the services were provided, so that if you were subjected to some sort of embarrassment or discomfort, then this could be a ground of complaint. It's like saying, I'm going to use an example. I mean, we're speaking about disability here, but let's just say you go to a supermarket and you were heckled or abused by staff because of your race. Now, you could argue that the supermarket might try to argue, well, we didn't deny you, you know, the ability to come in. You could have taken it. We didn't tell you you couldn't cash your items, so we didn't deny you the services of the supermarket. You were perfectly free to take your rice, flour, sugar, and go to the cashier and cash it. So you weren't denied the services. But if you were subjected to some sort of abuse by the supermarket, then you might have felt, well, I don't want to shop here, or why should I shop here, or why should I buy my products here? So that it's not just the denial of the goods and services, but the manner in which the goods and services were provided to you might have been something that caused you abuse, embarrassment, discomfort on the basis of these status grounds. So again, we're just looking at you know, the information provided here. Okay, she was trying to get treatment. So if she was the one getting treatment and she feels that that she was discriminated against in the provision of this treatment, there's always a thin line, I'm being blunt with you, between a medical diagnosis. If it is the doctor told her that as part of his medical professional opinion, then it might be difficult to say that she was discriminated against. If it was I don't know the facts, but if it was the nurse just made this as a by the way comment, then perhaps that would be different. But if it is the doctor said something about, you know, this is in my medical professional opinion, I am diagnosing this condition, then I don't really think you could say, well, I'm being discriminated against because the doctor gave me a diagnosis that I don't want to hear. So again, what I'm trying to say, each case would always turn on its own particular facts.
Thank you, Karen. We have another question. You would have covered it earlier, so if you don't mind, just briefly going through it.
Yes, I see. Mr. Dane Manick-Chan, yes. As I indicated, we have made recommendations for amendments to the Equal Opportunity Act to include age and sexual orientation. What you spoke about an ex-offender, that is actually something that exists in other countries, but unfortunately, there's no such legislation in this country. In other countries, they have legislation for what are known as spent offenses. Let us say you commit a minor offense. Every offense, not all offenses. If you're the victim, you wouldn't think it's minor, but you know, in the grand scheme of things, it's not a major offense, and you've served your time or you've been released, and after a number of years have passed, and you have not reoffended, you have not done what is called recidivism, that is to say you've kept a clean record, then in other countries, this offense is stricken from your record. So to use a local example, if you apply for a police certificate of character, then that will not show up on your police certificate of character because it's called a spent offense. We have no such legislation in this country. With respect to sexual orientation, we have made a recommendation for amendment, but I don't know if you've seen recently where the Attorney General has spoken He said that there are about 27 laws in Trinidad and Tobago that discriminate on the basis of sexual orientation, including things like the Immigration Act, the marriage, all of the individual marriage acts. You know, the marriage act. There's a marriage act, and then there are individual marriage act, like Hindu, Muslim, as it will. All of these acts, and he listed a lot of these legislations that discriminate against sexual orientation, including, for example, the Domestic Violence Act, the Cohabitational Relations Act. But there is a matter which I'm sure you might be familiar with, the Jason Jones matter, that was decided by the High Court. By the High Court ruled that the sections of the Sexual Offences Act that criminalize homosexual conduct are illegal because at the end of the day, the law as it stands is that sexual activity between men, between same-sex men and same-sex women is a criminal offense under the Sexual Offences Act. The court has ruled that this section is illegal and unconstitutional, and the Attorney General has filed an appeal to the Court of Appeal. So it is pending before the Court of Appeal. It has not come up as yet. There's no date fixed for hearing. And the Attorney General has said, I think it was just about 2 or 3 months ago, he said that the matter is of such importance that even after the Court of Appeal rules, it is likely to go to the Privy Council in London. And he has indicated that he is not going to tackle any of the laws, which were including the Equal Opportunity Act, with respect to sexual orientation, until after that matter has been adjudicated upon by the Privy Council. We continue to advocate for this amendment, and that is all we can do at this point. We can advocate. We are advocating that this amendment, the amendment to the Equal Opportunity Act, can be made without having to wait on the judgment of the Privy Council in Jason Jones, if and when that happens, you know, a number of years down the road. So we advocate for that, but at the same time, you know, this is the Attorney General has publicly articulated this position. You can Google it and find it, so that for the most part, we can say that it is not likely that the proposed amendments on sexual orientation would get anywhere in the foreseeable future, because again, we are awaiting that judgment. Now, with respect to gate over a certain age, yes, I'm seeing another question from Dean. When the government did indicate that they were denying gates to persons over the age of 50, the commission did issue a press release saying that was discrimination on the basis of age and it should be reconsidered. But as you would appreciate, age is not a status ground under the Equal Opportunity Act, so that all we could have done is said that this is an area that the government should reconsider, but we couldn't say that it was illegal or wrong, because there was no law preventing the government from doing that. Yes.
Renato has a follow-up.
Yes.
Renato asked earlier about the time frame for meetings and so on. He said, I may have missed it, but is there a facility for consultation as it relates to if a breach or breaches occurred? Example, can you call to explain the situation and the time frame of the offenses, and based on that phone call with the person, can you have a case or?
Well, yes. Well, in the past, as I said, when we had one of our offices were open to the public, we would say you can walk in and speak to someone. Now, because we're working from home, you would have to call and leave a number, and somebody would call you back and speak to you. So that yes, so you can have a consultation with a member of staff, but as I said, it's not just a matter of just walking in and getting it. It's because of COVID-19, everything takes a little bit longer. But you can call or you can email again through our website. And Shelley had given us the email addresses. You can email, and again, leave your phone number and a brief description of what happened, and someone would call you back at within a few days. It's not going to be overnight, but within a few days you would get a return phone calls.
Yes, I think it's safe to say if you're in doubt, to still come to us and we'll be able to clarify. And advise whether or not they can lodge a complaint, whether or not the status ground was tied to the category, and so on.
Yes.
Yeah. Okay. That's okay, Renato. Just to repeat again, the email that you can send your complaints to is
Mhm.
complaints@eoc.gov.tt or communications@eoc.gov.tt. You can also go to our website, www.equalopportunity.gov.tt. You can mail in your complaints. Because of COVID-19, we aren't accepting deliveries. Otherwise, you'll be able to deliver your complaint to our office. Or even when we're doing our outreach activities, you can lodge a complaint then, right? But the facilities available right now, email, website, mailing. Yeah. We don't have any further questions, but what I think is important to say at this point, well, to repeat, one, our services up until the stage of conciliation are free of charge, right? So all the services I mentioned earlier, including public education sessions, partnerships, presentations on webinars and so on, all free of charge for us to investigate your complaints free of charge, the conciliation process, which is basically getting both parties into a room to more or less mediate the particular situation free of charge, right? Also, Haran, you went
Yes.
into fines earlier,
Mhm.
right? For those who don't respond to your notice, right?
Yes. Mhm.
Could you just go into victimization for me, please, just a bit? So let's say I work at an organization, I lodged a complaint, and all of a sudden I am being treated differently by my employer.
Yes. Yeah, so the Act also protects those who attempted to, or who have lodged a complaint or have attempted to enforce their rights under the Act. So, and that is a separate area known as victimization, which you can complain about. So let's just say you have lodged a complaint against your employer, and subsequent to you lodging your complaint, you now find that you're receiving differential treatment or less favorable treatment. So for example, you're being excluded from meetings. That a lot of the examples I use are really pre-COVID. Like, let's just say you're not being sent on training or conference, which right now it's not really the case. But you would know what it is that you're experiencing, and as I say, to use the local expression, their face changed towards you. You're not getting a good assignments or that sort of thing, or you're getting now poor performance appraisals or bad reviews, that sort of thing. You can lodge a second complaint with the commission for victimization for having lodged this previous complaint. The legislation on victimization extends not only to the person who lodged a complaint, but let's just say I have lodged a complaint and I have identified Shelley as my witness, so that Shelley is now going to give evidence in my favor. And the employer now starts to treat Shelley badly. Again, using the same examples, their face changes towards her. Then, although Shelley is not the one who lodged the complaint, but she's being victimized because she's giving evidence in my favor or supporting my complaint, then she can also lodge a complaint of victimization, by the employer. And it's not just only lodging a complaint. Let's just say when I say lodging a complaint, not just lodging a complaint with the commission, a formal complaint, but let us say you tell your employer, well, I'm going to lodge a complaint, or not even just I'm going to lodge a complaint, but you tell your employer that what they're doing is wrong, what they're doing is discriminatory. So in other words, you've raised issues of equality of treatment and fairness and discrimination. And subsequent to that, you start receiving what I call the less favorable treatment, which I just went into, then you can lodge a complaint of victimization. So the grounds on which you can lodge a complaint of victimization are where you receive less favorable treatment from your employer, where you have or where you've indicated your intention to, or they're suspected that you have, one, lodged a complaint, you've given evidence in favor of someone who's lodged a complaint, or you've raised issues of fairness and equality and discrimination with your employer.
Yes. And I think the Act really and truly takes into consideration the barriers that might present itself to a person that might discourage them from lodging a complaint. So if you lodge a complaint and you've been victimized, don't worry, the Act also covers that. Right?
Yes.
Before we close off, Haran, could you just go into some details, because I think many people believe that you can only lodge a complaint against your employer or an organization. So could you go into some details about who you can lodge a complaint against, if it has to be a corporate body or body corporate, as you say in legal terms, or I can lodge a complaint against an individual as well?
Yes. Well, it's not just your employer, but you could also lodge a complaint against a prospective employer, because many times that's really where discrimination takes place. It's not really your employer is discriminating against you, but someone who you apply to a job for. I mean, sometimes that's where the discrimination takes place, that you were not selected for the job, you were not shortlisted, you were not interviewed, and there's a whole process of recruitment and selection. So either you were not shortlisted, you were not interviewed, or you were not hired into the job. You can lodge a complaint of discrimination against a prospective employer if you think that you were not hired because of one of these characteristics: your race, your religion, your ethnicity, your disability, that sort of thing. Also, too, under the Equal Opportunity Act, employment is there's a wider definition of employment than, say, under the Industrial Relations Act, because under the Industrial Relations Act, you have a number of categories of persons who are considered. Well, that act speaks of workers, and there are a large category of persons who are not considered workers. But under the Equal Opportunity Act, anyone in any employment relationship is considered an employee for the purposes of the Act. And as I mentioned, it even goes on to extend to people who are not in the employment relationship. That is to say, people who are applying, prospective applicants. But let's just say you're working under a contract of service. Normally in a lot of courts, you would hear these arguments: are you on a contract of services or a contract for service? But under the Equal Opportunity Act, any form of employment relationship, whether you are an OJT, whether you're an apprentice, whether you're an independent contractor, any form of employment relationship is covered, and you can lodge a complaint of discrimination in your employment relationship.
And even outside of employment, Aaron. So, for instance, a landlord.
Yes. Yes. Well, again, so that's discrimination in employment. And when we look at our statistics, more than 75% of our complaints fall within discrimination in employment. But there are 3 other areas which are sometimes underutilized. Again, the provision of goods and services, the provision of accommodation, and the provision of education. So that with respect to accommodation, let us say you apply, you see a property listed in the classifieds and you call, but then you see something written, or they say, no, we're not going to rent to people of a certain race or people of a certain gender or that sort of thing. You can lodge a complaint with the Equal Opportunity Commission based on that. So that it's not just employers. I mean, although we speak mostly about employers, it's also you can lodge a complaint against your landlord or your prospective landlord, again, because it's not just that's what we said with employers. It's not just your actual, but your prospective in all other areas. If you apply to rent somewhere and your prospective landlord refuses you, and you believe that this refusal is because of one of these characteristics, then you can lodge a complaint with the commission about your landlord's refusal to rent the premises to you or your prospective landlord. And similarly, when you go into a store, any form of the provisions of goods and services, we had the example earlier where someone went to a doctor's office and they said the nurse told them something. That is, again, you were seeking medical services. So any form of provision of goods and services, whether by a store, whether by a doctor, whether by an accountant, any goods or services that you're seeking. And I also need to stress that it's not just only the private sector, but the public sector. So because someone may use the example of seeking gate for persons of a certain age, and gate is a goods and service that the public sector provides, that the Ministry of Education or Ministry of, well, what used to be the tertiary education provides, so that the services provided by any public sector or private sector entity, you can lodge a complaint about that.
Yes, I'm happy you mentioned, because Ronaldo just asked whether or not you're covered if the employer is in the public service.
Yes. Yes. Mm-hmm.
So it's both public sector, private sector, companies or organizations, or individuals as well.
Yes.
Right. So I think we covered quite a bit today. We got a few questions. Thank you for your questions. I trust that you would have gotten answers that you're satisfied with. And we would, Haran, before I close off, thank you so much
Sure.
for coming on the session today and answering these questions. And thank you for all our viewers and those.
Sorry, I just saw that's one last question I wanted to answer to Nigel Maraj. What about discrimination?
I was about to point that
out. The definition of disability is fairly wide. You know, when people think about disability, we tend to think about physical disability. That is to say, the person, you know, is an amputee. They use a wheelchair. The things that we could physically see. You know, they're missing a limb, they're missing a part of their body. But disability also includes what you call the hidden disabilities, such as the mental or psychological conditions. So that a person who has schizophrenia, who has bipolar disorder, they are also considered disabled as well. And it's something we always talk about when we go to, you know, you said we offer these publics, we offer a lot of training sessions free of charge. And when we, you know, used to do these sessions with a lot of employers, we'd ask them about, well, your disability policy, and they will say things, well, we have accessible bathrooms, we have wheelchair ramps. You know, these are what are called accessibility and design issues, which would help accommodate a person with a physical disability. But then we say, well, what about the person who is exhibiting symptoms of paranoia, schizophrenia, bipolar disorder, and all of these mental conditions? How do you treat with that? So it's just, I think that's a very good question. And I'd like to close on that note to say that disability is not just the physical things that you can see, but also the intellectual ones, such as learning disorders. We will talk about things like, you know, Down syndrome. We are into Down Syndrome Awareness Month, so let us be aware about that, cerebral palsy and Down syndrome. But even those, they might manifest in some physical form. So they're the hidden ones that you can't see, which is where, like I said, a person may not physically manifest any symptoms of it, but you know, because a lot of these mental or psychological conditions, they don't manifest in a physical manner in the ways that the intellectual or learning ones might manifest, you know, in a physical manner.
Yeah. Thank you, Haran. Yes. So with that.
So that is so that's just to mention on disability, and discrimination due to mental illness would fall under disability.
Yes. Okay. Okay. Thank you, Haran, for that. Let's close off the session today. It was very informative, very engaging. Thank you for your questions. You can head over to our website, www.equalopportunity.gov.tt, or you can follow up with any questions to communications@eoc.gov.tt. And we will see you in 2 weeks' time, where we will have another interactive session. So until then, everybody, be safe and take care.
Okay, yes. All right. Thank you all and have a good day.